Hello everybody, welcome to today's video, an introduction to the Australian legal system. I'm going to walk you through the overview basics. So this is a high level overview of some of the things that you should make sure that you are aware of the legal system. We're looking at South Australia in particular, but this applies across Australia. I'm also going to show you how I would take notes for this if I was in a lecture or if I was in class. It's really important to make sure that your notes are consistent, they're clean, they're tidy, makes exam time a whole lot easier and revision time a whole lot easier. So let's get started with, well, what is the law? So law is a product of the Australian social system, of our rules, of what we believe in, and it's not static. So the law changes by responding to the current social and political values of the Australian culture. And it governs our relationships through contract, tort, property, succession, trust, family law, and also governs public relationships as well through, like, for example, state criminal law or constitutional or administrative law. So we know that Australia has laws, but where do we get our laws from? So sources of law. There are two main sources of law in Australia. This is case law or common law. So those two things are actually referring to the same type of law. So you'll see them used interchangeably. And what is case law or common law? Well, that is law which is based on the decision of judges. Then we also have legislation. And legislation is the law which is made by Parliament. So those are our two sources of law, and this is what we use under rules in IRAC. So when we're writing and the problem question asks us to use the rules of law, we are using case law, common law, or legislation. Now, case law, it gets a little bit tricky. I'm just going to break it down a little bit more. So case law can get a little bit tricky because we have hundreds of years of cases to draw on. And these decisions from these cases have developed a body of legal principles, which we know as common law or case law, which is declared by judges. And we know that in a case before the court, the parties to the action present the evidence they need to support their case. The judge listens to the evidence, decides what evidence is relevant, yada, yada, yada. And then they apply that evidence to the law and make a decision which is binding on the parties. And it is the law declared by the judge in the reasons for the court's decision which directly affects the parties to the case. So when we're looking at case law or common law, we are looking at the law declared by the judges in the reasons for the court's decision. That's why it's important to read the case as a whole where you can, because if you only read a summary page on an internet site, you're not necessarily going to understand the full reasons for the court's decision, which means that you might miss a key fact as to why that decision was reached. So this will also affect indirectly people bringing actions involving similar legal principles. So when to use case law, when we have similar facts or legal issues or principles before another court in that jurisdiction, or for example, for us, it would be our case study, etc., etc. Why? Because of the doctrine of precedent, which we're going to touch on further. So what does precedent mean? Well, it means that the judges are bound to follow interpretations of the law made by judges in higher courts, particularly in cases with similar facts, similar legal principles. So what are we looking for that is important when deciding if case law is applicable? Well, we are looking for, is the court the same level or higher? So for example, if you have a really low level court, it's not going to be as powerful of a decision as, say, for example, the High Court. Do we have similar facts? So there's no point using a case, and this is where I see students come unstuck. There is no point using a case that literally has no resemblance to your case scenario or the problem question, because they don't necessarily apply. You need to be looking for similar facts. We're looking for similar legal issues, principles under the question. And we are also, if we can, looking for the explanation of why the court chose to follow or not follow a previous decision. So over the years, the same initial case will get discussed throughout subsequent cases. And if we can look for those explanations about why or why not the court has chosen to follow a previous decision, this can help inform us about our problem question. And often you will find that your lecturer has chosen a problem question which is very similar to a real case that exists that you have discussed in your lecture notes. And we also should note that courts are not necessarily bound to follow their own earlier decisions, although they often do. So it's important to note legislation, 100% binding, case law, it's progressive, it's changing, it's flowing. It's not necessarily 100% binding. And decisions of courts outside of Australia, do we think that they are going to be binding? Not binding on Australian courts. So if you find a really great American case law or a UK case, that's great. They can be used to assist or guide the Australian courts, but they are not binding. So make sure that when using them, you are very clear with your wording that they are not binding, but they can be used to assist or guide. And often we see a lot of UK cases being used, but again, it's assisting or guiding. And when do we look to courts outside of Australia? So if it's a matter which we see on a day in, day out basis in Australia, are we going to use an Australian case or a UK case, for example? Before looking to overseas. So if we can, we want to look for an Australian case. If it is a really tricky set of facts / legal issue that we haven't seen in Australia, that's when we can look elsewhere. So it's just important to know when we use it and when we don't. And we should know that the decision of the highest court within a particular jurisdiction is final. So for example, ideally, we want to find high court cases, as this is the highest court in the Australian court system. Oops. So that for me, nice little notes there on the different types of or sources of law and when we might use what. So that's all about the case law. So actually what I might do, let's tidy this up a little bit, because it's important that we have neat notes. Like I said, it's easy to start now rather than at the end when you're in a scramble in SWOTVAC. So let's get things neat and tidy now. All right, so now we're going to have a look at legislation. So we've gone through a bit about the case law. Excellent. We know what we're looking for. Now let's look to legislation. So legislation, again, it's Parliament-made law, which is binding on all courts and judges. So if legislation exists for the legal issue you have encountered in your problem question, use this first, then use case law if required. However, not every legal issue will have legislation. But when it exists, use it. Okay, so laws made by the Commonwealth or state parliament are called acts or statutes or legislation. So just like above here, how we know that it can be case law or common law, you'll see acts, statutes, legislation. That's what we're referring to. Now we know that when an act is in draft form, we're not going to use that in our case scenario response. So bills equal legislation in draft form. We don't want to use these in our responses because they can be passed or rejected. So we want to make sure that we're using things that are already 100% where we're confident that are going to be binding in the courts. And in addition to acts or legislation, there are also laws covering administrative details and other matters which are not easily dealt with in legislation. So, for example, these might be rules, regulations, bylaws. So along with our key legislation, we also have something called subordinate or delegated legislation. And these are the regulations. We have the rules. We have bylaws. And why do we have them? Well, that's because Parliament has dedicated its powers to pass these types of laws to another body. So that might be to a minister or to a local council or to a government department. So then we're going to do interaction between legislation and case law. Whoops. There we go. So in an exam or in a problem question, particularly if you are new to law, and this is again designed for first year law students, we might forget what's what. We're just trying to get something on the page to get our answer down. So we need to remember that an act overrules the common law if both apply in the same area. And this is why we want to go to legislation first and not use cases from, say, the 1800s without checking if anything more modern exists. So often legislation will add to an area of common law. So legislation is often made once numerous cases have gone to court all on the same issue. The judges are seeing it quite often, and Parliament says, hey, you know what, this is a regular issue. Let's make some legislation so it's crystal clear what we mean. So legislation attempts to control future activity. Therefore, it cannot predict or cover every possible scenario we may see in the world. And that's where then it will go to the court for the court's interpretation. So that's when we use both of them. Sometimes an act might be a bit ambiguous or a bit vague, and the interpretation by the courts will be used to predict particular cases in the future. I will now jump to the Australian constitutional system. So here we go. Sources of law. We are now in our notes going to page break, Australian constitutional system. And I'm going to continue this in the next video so that those of you who want to study in bite-sized bits can tune in. So watch for the next video if you are interested in seeing my notes on the Australian constitutional system. Thank you.